Comedy.
It was 785 calling in.
Hi, it's Eileen from the revisor's office.
Okay, just checking.
Thanks, sorry. Missed the first question.
The committee is online, yes.
Good morning, committee. We will call the Committee for Financial Institutions and Insurance to order. First item on the agenda is request for bill introduction. Senator Peck, I believe you have one.
Thank you, Mr. Chairman. Yes, I have an RS number 21 RS 0670. Again, that's 0670. Has to do with peer-to-peer car sharing.
Any objection to that bill introduction? Seeing none, it will be introduced. Committee, next we will open a hearing on Senate Bill 29, a favorite, very complicated bill that we do every year in this committee. Eileen, I'm going to call on you for a brief overview.
Thank you, Mr. Chair. Can you hear me?
Yeah, you're a little quiet, but we'll get through it.
Is this better?
That's much better.
Okay. Thank you, Mr. Chair. Good morning, committee. Senate Bill 29 is our annual date change bill, and it amends KSA 40-2C01. Each year, insurers are required to file their risk-based capital report with the Commissioner of Insurance and with the NAIC in accordance with the formula set forth in the RBC instructions. The instructions change each year because the effective date of the instructions that insurers use to file the report changes every year to the last day of the preceding year. And that amendment, you can see in the bill, appears on page 2 in line 2, where the year changes from 2019 to 2020. And with that, I can stand for questions.
Thank you, Eileen. Committee, are there any questions? Senator Pittman.
Thank you, Mr. Chair. I'm just curious, why do we do it every year? Is there not a way to fix it permanently?
Well, the proponents can certainly tell you their side, and from a chairman's perspective, it's a nice vehicle to have in your pocket at a later time.
Mr. Chair?
Yes, Eileen?
Sorry. From a legal perspective, if we were to do that, it would be an unlawful delegation, and it would be unconstitutional.
From the legal perspective, there's your answer. I think we'll leave it alone.
The vehicle thing is just kind of a nice side effect.
Okay, at this time, we will turn our attention to the proponents. We have Lee Monisette from the Kansas Insurance Department. Welcome, Lee.
Thank you, Mr. Chairman, members of the committee. Lee Monisette with the Insurance Department. I have my written testimony kind of outlines what the revisor's office already discussed. And then if I could add just beyond the constitutional concern, Senator Pittman, would be there are subtle changes each year that are made to this report. Any sort of significant changes would take place over a number of years with a bunch of really smart actuaries kind of haggling all of this out. But by having this annual date change, if there were to be something problematic in that capital requirement, particular for our smaller insurers, we would be able to maintain some level of autonomy and ability to push back on that. So beyond the constitutional, we don't want to just cede the authority to an unelected body. I'd be happy to stand for questions.
Thank you, Lee. Committee, are there any questions? I see none. You must have done a great job. Are there any additional proponents to Senate Bill 29? Are there any opponents to Senate Bill 29? Are there any neutrals? Seeing none, we will close the hearing on Senate Bill 29. We will now open the hearing on Senate Bill 30. Eileen, can you give us an overview?
I sure can, Mr. Chair. Thank you. Senate Bill 30 amends KSA 75-3036 and 77-547 and KSA 2020-17-12A508, 17-12A601, and 17-12A609, and it establishes the Securities Act Victim Restitution Program and the Securities Act Victim Restitution Fund. So Section 1 amends KSA 2020-17-12A508 pertaining to criminal penalties and the statute of limitations for intentional violations of the Kansas Uniform Securities Act. So under current law, no prosecution for an intentional violation may commence more than 10 years after the alleged violation if the victim is the Kansas Public Employees Retirement System, or KPERS. Prosecution for any other intentional violation of the Kansas Uniform Securities Act may not commence more than 5 years after the alleged violation. So Senate Bill 30 would strike that 5-year statute of limitations and make the statute of limitations a uniform 10 years for all intentional violations of that Securities Act. Section 2 amends KSA 77-547 pertaining to identification of the agency head or administrator for purposes of administrative proceedings under the Kansas Administrative Procedure Act, or CAPA. Under current law, for purposes of administrative hearings for the insurance department under CAPA, the agency head is the Commissioner of Insurance or the Assistant Commissioner of Insurance when acting on the Commissioner's behalf. The bill would identify the Securities Commissioner or the Assistant Commissioner of Insurance as administrator for purposes of administrative hearings for the Office of Securities Commissioner under the Insurance Department for purposes of CAPA. Section 3 amends KSA 2020 sub 17-12A601 by creating a Securities Act victim restitution program and creating the fund from which restitution assistance is paid and detailing the specifics of the program. The Securities Act victim restitution program's purpose is to provide restitution assistance to victims of securities violations who were awarded restitution as the result of a legal or administrative action for violations of the Kansas Uniform Securities Act, but who have no reasonable likelihood of receiving the full amount of the awarded restitution. The bill states that a claimant must apply for restitution assistance and that the administrator must receive the claimant's application no later than 2 years after the date of the final order. The administrator would have full discretion in granting any award of restitution assistance in whole or in part to a claimant. To receive restitution assistance, a claimant must demonstrate eligibility for such assistance, file that timely application with the administrator, and the administrator must determine that there is no reasonable likelihood that the claimant will receive the full amount of restitution awarded by the final order. Restitution is limited to the lesser of either $25,000 or 25% of the amount of restitution awarded in the final order, excluding any interest awarded, that remains unpaid at the time the administrator awards such restitution assistance. And if the victim is a vulnerable person, the maximum amount of restitution assistance doubles then to the lesser of either $50,000 or 50% of the amount of the restitution awarded in the final order, again, excluding any interest awarded, that remains unpaid at the time the administrator awards the restitution assistance. Section 4 amends KSA 17-12A609 to state that a final order of the administrator is subject to judicial review, except in those instances pertaining to the Securities Act Victim Restitution Program Fund and applications for assistance. And Section 5 amends KSA 75-3036 to add the Securities Act Victim Restitution Fund to the list of funds that are statutorily required to be used for the purpose set forth and for no other governmental purpose. And with that, Mr. Chair, I can stand for questions.
Thank you, Eileen. Committee, are there questions of the revisers? Senator Hildebrand.
Thank you, Mr. Chairman. Thank you, Eileen. My question is on line 6, page 6, line 21 through 24.
Okay.
And I'm a little bit curious on what a natural persons would be, what that definition is.
So a person can be an entity such as a business or a natural person, meaning a human being. So what we're saying there is only a human being, not a business entity, a corporation, something like that.
Thank you.
You bet.
Committee, are there additional questions of the reviser? Senator Fagg.
Thank you, Mr. Chairman. I was wondering, Eileen, why, if the 10 years with Capers and then 5 years for everybody else, and you decided to go 10, why the 10-year versus not going 5 on everything?
Senator Fagg, I think that question is better suited for the conferee. That's kind of a policy question. I can talk to the legal portion of the bill. Policy questions are better addressed by the proponents.
Senator Pittman.
Thank you, Mr. Chair. Eileen, if it says here that it's on section 4 of your review, it amends the ks 17-12A609 to it's subject to judicial review except those determinations pertaining to the Securities Act Victim Restitution Program. Is that basically saying that any orders by the administrator here are not subject to judicial review?
That's correct, sir.
So it's basically taking out any kind of award decision made by this administrator and then saying, hey, this is their decision, their only decision, and it's not subject to any review by anybody, even the judicial branch?
That's correct, and I'll share with you when the bill was being drafted. This is a reintroduction of a bill that we drafted last year, and we did want to verify that with the department, and that was what they wanted.
Committee, are there additional questions of Eileen? Seeing none, Eileen, thank you.
You're welcome, Mr. Chair.
We will now turn our attention to the proponents, Lee Modisette with the Kansas Insurance Department. Lee, welcome back up.
Thank you, Mr. Chair, members of the committee. Lee Modisette, Kansas Insurance Department. You have my written testimony, but I thought I might kind of go through kind of the department's thought processes with each of these changes. The first one being the question from Senator Fagg regarding the change. So there's kind of two parts. One, we felt like if CAPERS victims had the option of 10 years, we didn't see any reason why folks who would not be in the public employee retirement system shouldn't get that same opportunity. But there's also kind of some cases that we have experienced where the nature of securities victims and the award process and determining penalties is the early victims, who sometimes are the largest losses because they're the early investors in the fund. They may not come forward at all to tell us about falling victim to fraud for a number of reasons. There's kind of some psychology, investor psychology that comes into play, having to admit maybe you made a mistake, you know, things like that, thinking, hey, I couldn't have fallen victim to fraud, I'm smarter than that, and obviously we know that fraudsters are pretty creative. So we may not find out till 4, 5, 6, 7 years into a scheme that this is even taking place. And when it comes to the penalties for this unscrupulous behavior, anything past that 5-year period does not count in the aggregate total. So when you're looking at restitution and you're looking at criminal penalties for this behavior, anything outside of that 5 years is not able to be counted and is not cumulative. So we have several cases where we actually lost some of the ability to appropriately punish the individuals who took advantage of Kansans. So that's the justification, kind of two-part of moving to 10 years. That opens that window. We actually have 8 cases, or have had 8 cases in recent history that were outside the 5, but were within the 10-year window. The change on page 3 on A. This is where we allow the Assistant Commissioner of Insurance to also be a hearings officer. This is part of trying to, as we go through these statutory changes, finding the efficiencies and the cross-training and cross-use of staff between the securities and insurance divisions. And the commissioner ultimately is the agency head, so this allows her, in case we haven't had any hearings in the securities division, but should we, for example, our assistant commissioner is an attorney, our securities commissioner is not, and so it may be, circumstances may be appropriate to have the insurance commissioner, assistant commissioner as the hearing officer. And then the rest of the fund, the rest of the bill deals with the establishment of the fund. A couple of things, highlights I wanted to note. Eileen did a great job kind of summarizing the seed money and what the caps on these would be. This was actually a concept that came to us from our former Securities Commissioner, Commissioner Wagaman. He came to us from the Attorney General's office. He had administered the Victims' Compensation Fund there. He wanted to do something similar here. He retired at the end of last year, but we felt like this was still a really good concept. What may be I found surprising statistic is that kind of our tracking of restitution over the last 30, 40 years, if you fall victim to fraud, there's about less than 7% chance that you will actually recover your investment. And there's a number of reasons for that. Fraudsters are very creative at hiding their money, and they're very creative at putting it in accounts that their retirement accounts, so they have legal protection, things like that. And so this would certainly in no way, shape, or form make folks who fall victim to fraud whole, but the idea and the hope would be to lessen that just a little bit. And the money does not come from tax dollars. Securities division, like the insurance division, is funded by the industry and fees that the agents pay, and then obviously fines and penalties. And so it would be no tax dollars that would be used to start the fund, and then I think Eileen's adequately covered kind of how the fund works. So with that, I would stand for additional questions.
Thank you. Committee, are there questions? Senator Hildebrand?
Thank you, Mr. Chairman. Thank you, Lee, for your testimony. My question is on page 7, lines 7 through 16. Just curious of why there are two different penalties for two different groups of people, defined people. Sure. And does that go against equal justice?
So I can explain the thought process behind it, and then certainly these numbers are options, but the thought process was that if the number of folks who fall victim to fraud generally are going to be either in or near retirement age, and so the loss of that money at that stage of their life is more consequential than, say, a younger person. Falling victim to fraud is bad in either case, but the idea and the concept is that should their individual circumstances warrant it because of their particular situation, that they would be eligible for additional award. It also kind of fits in the trying to maintain the fund without we're trying to solve the vulnerability issue and create a fund that can sustain itself.
Thank you. Now, I do have a follow-up to that. So I'm not a fraudster, but if I was a fraudster and I read this bill and I thought, well, I can only pay a $25,000 fine versus a $50,000 fine, the vulnerable victim's not so credible now. Would that be an unintended consequence of diverting more attention to younger people like myself?
I think that's a good question. So I would say the note I would say here is that a fraudster's not going to look at this and think I can take more advantage of a younger person, because this is restitution that we would be essentially assisting outside of that. So the fraudster at this point has already been charged, convicted, and told by the court to pay restitution. This comes into play when those folks never pay. And so it's not going to matter the age of the victim from the fraudster standpoint, because they're never paying the restitution anyway. And that's the entire premise behind the establishment of the fund.
Thank you.
Committee, are there additional questions? Okay. Senator Holscher?
Thank you. Good morning. I have a question in regard to, you mentioned the $250,000 that is the startup comes from registration fees. I'm just curious, what do we currently do with the funds that come about because of those fees?
That's a good question, Senator. I'm trying to get familiar with the committee setup here. Right now, all of the excess funds that are generated by the securities division after our expenses are actually sent to the state general fund. And there is a pending litigation brought by the industry. Some investment advisors who have brought forward saying that those fees that they pay are designed and intended to regulate the securities industry. They're not meant to subsidize SGF. We're not, the insurance department, securities division is not a party to that lawsuit. It's the state of Kansas. So I can't say much kind of beyond that for a number of reasons, including not being a party to it. But currently, the excess funds, which annually are around 13 million, go to SGF.
Right, thank you so much.
Senator Pittman?
Thank you, Mr. Chair, and thank you, Lee, for being here. When you do speak to the people in the camera, it's best to look at the camera, I found when I've been on the online.
Perfect, thank you.
Just so you know, as a tip. I commend the insurance commissioner for actually putting this program together. We do have victims of fraud, and I know I have stakeholders out there. I got a couple of questions. One has to do with the sole discretion a piece of this, and then the fact that it's not judicial. There's no judicial or any other kind of review of the process. Can you talk about why you think that's important? And because it seems a little draconian, just to say we're going to make our own mind up and no one can question us. So just wondering what the thought pattern is there.
So that's a good question, Senator, and I want to check with our counsel to get the judicial review component in particular. But the general, I didn't touch on this in my oral, but in my written, we intend, if this bill were to become law, we would adopt a rules and application process ideally by the end of the year. And so the Victims Compensation Fund at the AG's office, as I understand it, is administered by whoever took Commissioner Wagaman's place, and it's there, that's what they do. And so the thought process here is that the restitution has already gone through the court process. The fraudster has already had all of their legal rights protected. The victim has had their legal rights looked at. Restitution has been ordered. This fund comes into play when that fraudster doesn't pay. And so from our perspective, it didn't make sense to go right back through that process that we've already been through. That is why we're here. They're not paying, and there's no, other than them going to jail for a period of time, there's no other recourse for that victim. And so from our perspective, this is we're dealing with the thing that we know and trying to help within a reasonable timeline get some funds to those folks who couldn't get it through the other legal methods.
With that in mind, I mean, it does seem with the two different levels of 25,000, 50,000, and the sole discretion being to this administrator, that there's not a lot of guidance as to who gets the money and who doesn't. In other words, it seems like a little arbitrary. Somebody could just say, well, they're vulnerable and they're not vulnerable because they're 25 and they're not 50. It doesn't seem to make a lot of sense to do it that way because it seems to open up ethical issues about who's getting the money and who's not. But I think that the core of this is really fantastic, and I'm glad we're doing it. But I do have some thoughts about why are we doing it with the two levels, and also the arbitrary nature of who gets it and who doesn't get it.
Sure, I appreciate that, Senator, and I'm happy to get a time to meet with you too to kind of flush that out more. The one thing I would say is that it won't be arbitrary in the sense that this is the authorization to do it. We will establish a process, guidelines, that sort of thing. The best example I can think of is, really for both sides of the House, when we have applications that have things that are flagged for a variety of reasons, there's a reasonableness even in the court system, right? How long ago was this? Have you shown remorse? Those sorts of things. And so I do think the individual circumstances can come into play because you and I may both fall victim to $30,000 in investment fraud, but my investments or my savings may be different than yours. And so yes, we suffered the same loss, but what is that loss as a relation to how it impacts my quality of life, right? And so more vulnerable victims, folks on the lower income scale, for example, seniors, fixed income, they have depending on their circumstance, they may have less opportunity to recover those funds than another victim. And so the idea there is to try to get the money to the most vulnerable, but making money available for all victims. Certainly, you know, we're also concerned about the longevity of the fund, to not have to, keep putting more money into it, each year, try to manage that. If the pending lawsuit were to change the, fee sweep process, then, maybe some of those funds, certainly we'd have to look at reducing fees in general, because it'd be reckless to try to spend that kind of money each year, but maybe some of those dollars could go to the fund to address that equalization issue. So there's certainly options to try to work on that.
The fund is $250,000, and if we were looking at $25,000, that's 10 victims. These investments often have millions of dollars. What are you looking at in terms of a sustainable option here? It doesn't seem like it would actually, there wouldn't be much compensation for that many victims of even one fraud scheme, it seems like. What are your thoughts on that?
So we end up with a lot of victims that maybe have smaller amounts, and there are some that are bigger cases where there are large amounts per victim. And so certainly we run the risk that there would be some folks who would exceed this cap, right? There's a kind of to the concern about the distinction, there's a compelling argument, I think, to be made that by putting a cap on it, you're also saying anybody above that falls victim above this amount, that we're only going to help you recover a certain amount too, right? And so if the money's not limitless, and it wouldn't be, we'd have to look at, okay, what are reasonable parameters within the structure? And so these dollar amounts were put together based on a historic look at our folks who have fallen victim and what we think can be reasonably paid and have a sustainable fund.
Senator Fagg.
Thank you, Mr. Chairman. Lee, I had two questions. Can you give me an idea how many cases, like in the last year, that you have how bad a problem is this in Kansas?
Well, it's candidly a difficult problem to measure for a number of reasons. There may be one victim in Kansas, but the scheme spreads 5 or 6 states, and so the problem of investment fraud itself is there's a lot of academic literature on this. It's actually quite difficult to measure compared to, say, the gift card scams or the IRS scams, things like that.
Second question, do you try to collect from the fraudster even if he's in jail? And the reason I'm saying that, let's say 3 or 4 years down the road, grandma, he inherited some money. So I would think on the backside there ought to be some, I just wonder if you did any of that kind of stuff.
Yeah, so the court orders restitution, and then we track that payment or lack thereof in most cases, and do what we can to track that down. Some of the things that we run into is that they may move from Kansas to another state. Fraudsters, they were able to scam folks, right? So they're quite creative in avoiding us or being a step ahead. So actually recovering those funds that have been ordered, we do everything we can, but it can be difficult.
Thank you.
Additional comments or questions? Seeing none, Lee, thank you very much.
Mr. Chairman.
Are there any additional proponents to Senate Bill 30? Are there any opponents to Senate Bill 30? You can. Are there any neutrals to Senate Bill 30? Eileen, we have a question from Senator Pittman.
Mr. Chair, just on your section 1 of your review, Senator Fagg had asked about the 10-year from the 5-year. Had you looked at other states and what their timelines are for the statute of limitations on this particular piece, by chance?
I have not. So the request was to change the statute of limitations to 10 years and to strike that 5-year. With the request like that, we don't do any additional research.
Seeing No one else who wishes to testify on Senate Bill 30, we will close the hearing on Senate Bill 30. Committee, that completes our work for today. Tomorrow, we will hear Senate Bill 28, also from the Insurance Department. And then Thursday, I would like to work bills previously heard. So that could be specifically the Bankers Bill, Senate Bill 15 that we heard last week. And there were a number, I think there were 4 suggestions for amendments last week when we heard that. 3 from the Treasurer's Office, and 1 from the technical type from the Bankers Association and Farm Credit. I have requested those, so rather than have duplication on the revisor, certainly open to any other amendments that you may wish, but just want to let you know that I have requested those 4 that were specifically mentioned in the hearing. And then if the committee is comfortable with the 2 bills that we've heard today and possibly the one tomorrow, we may also work those on Thursday. And then we'll have a full week next week. Seeing no other business, we are adjourned for the day.